And good morning, everyone, and thanks so much for joining us. I am sorry that we can't meet in person still, but we do have people joining us from all over the country, including England, Wales and Scotland. So virtual events still do have some benefits. We're here today to speak about pension transfers and scams, which we all think is one of the most pressing issues in the industry today. For those of you who don't know me, I'm Suzanne Padmore. I'm a partner in our pensions disputes team, and I regularly advise trustees on suspicious transfer queries. I also advise and act for FCA regulated entities in relation to their roles in the transfer process. I'm joined by Amy Coder-Bandaloo, who's a senior associate in our pensions disputes team. She has experience of advising trustees on pension transfer issues too, including how to approach red flags and possible scam situations. Ralph Lovesey, who's a director in our financial services team, specialising in regulatory advice, including in relation to FCA supervisory and enforcement action. And Susanna Young, who's a partner in our pension team. And Sue has been advising trustee boards for over 15 years and has recently been seeing more and more suspicious transfers referred to the trustee boards by scheme administrators. I realise that we've given the webinar today the tagline, all you need to know in a fast-changing environment. As you may well know, and we've certainly discovered in preparing for today, this is an extremely current and pressing issue, and it would be impossible to cover everything that's happening in response to pension scam risk in the 45 minutes that we will be speaking today. And as Connie said, we're hoping to leave that 15 minutes at the end for questions, but we will cover as much as we can. To demonstrate that point, I was planning to put together a concise legal and regulatory overview, but this soon turned into this word cloud on the slide, which I think fairly reflects all of the initiatives and organisations which are currently engaged in the prevention of pension scams. To draw out just a few examples, the pensions regulator has identified tackling scams as a strategic priority from the first year of its recently announced corporate plan from now to 2024. It's introduced a new scam model in its trustee toolkit, and it's calling for industry organisations to sign up to their pledge to combat pension scams. The FCA has just closed a consultation on claims management phoenixing, which is something that I'll return to briefly later, and is consulting on strengthening rules in relation to high-risk investments. In terms of the law, draft regulations and a DWP consultation on the statutory right to transfer is currently underway. We did notice that the PPF is not on this slide, even though it should be. It's recently obtained a court ruling which said that the Fraud Compensation Fund, which it operates, is available in certain circumstances for victims of occupational pensions liberation scams. So there's something that isn't even in that word cloud. So there's certainly a lot of activity for the prevention of scams, and we'll cover some of the key developments today. Before moving on, I would just like to mention Project Bloom, which was launched quite a while ago in 2014 as an umbrella initiative to create partnerships across the industry to combat scams. Today, it remains without a particular statutory footing and without direct funding. And it does remain a question, I think, whether this approach continues to be appropriate with the risk of scams seeming to be on the increase, particularly in light of the COVID pandemic. There is a real concern that scammers are taking advantage of people's vulnerabilities even more now. So before going on to the content in detail, I think it is worth pausing just to check what we're talking about when we refer to a pension scam. The DWP recently issued its first report into its inquiry into pension savings generally, and the first report was a review of the risk of pension scams, and it acknowledged that there isn't a universal definition of a pension scam, but the report does acknowledge and encourage the use of the definition used by the pension scams industry group. So this is shown on the slide, and it covers the following, which is quite a broad definition. So the marketing of products and arrangements and unsuccessful attempts by a scammer to do things like release funds from an HMRC registered scheme, encourage people to access their pensions and invest in inappropriate investments, encourage people to transfer their pensions and invest in inappropriate investments, or to mislead someone about the nature, related risks, or whether or not an investment is appropriate for that individual. So it is a very broad definition, and it's certainly not limited to scammers obtaining access to funds and sailing off into the sunset. It does cover the last aspect of misleading someone about the risks and the appropriateness of investments. It's also worth noting, I think, that there's a trend towards secondary scammers. This is where perpetrators of a scam appear again, working in another company, for example, a claims management company, essentially to profit twice from their original wrong, which is what is known as phoenixing. Action has started on that for a while. For example, the FSCS is working hard in tandem with other organisations such as the SFO and FCA to gather data from the claims that they see to prevent this sort of behaviour. So if you'll forgive me for that sort of scene setting, I'll turn to our specific agenda for today. Ralph will talk first about FCA action on scams and recent case law. I will give a brief update on best practice and relevant guidance for FCA regulated entities. Sue Young will then talk about the members' statutory right to transfer and upcoming changes to that. Amy will talk through some recent tricky transfer scenarios that we have dealt with. And finally, I will then comment on the remedies available to members if they are victim to a scam and lose some or all of their pension savings. I did want to show that sort of order of topics is what we see as the members' typical journey through a pension transfer and a scam. I think it's easy to think that the journey starts with a transfer out of safeguarded benefits, but usually the first thing that the member has interactions with is a regulated entity or possibly an unregulated entity. In a scam, this could be an advert on social media or a direct approach to the member. You will all probably know that cold calling was banned a few years ago, but serious concerns now exist, particularly with online advertising. Secondly, the transferee will usually have a view or be encouraged to invest in particular investments, and most recently the suspicious activity we've seen involves the transfer to SIPs. And there should always be, under the statutory right to transfer, an involvement of an IFA to give pension transfer advice. So thirdly, that's the stage when the trustees get involved of the original scheme to assess the transfer request. And then finally, we'll know the likely member outcomes and what remedies might be available to members. So with that introduction, I will hand over to Ralph to talk about FCA action on scams and recent case law.
Thanks, Suzanne. So looking through a few recent actions that the FCA has been taking in relation to scams generally, we have a range of avenues that the FCA is pursuing. Firstly, they are undertaking same-day monitoring to capture suspicious advertising as they see it. They look to do this within 24 hours after it first appears, which is quite impressive, really. They will then issue warnings on the same day so that their warning list can be updated daily. And the head of enforcement has emphasized that this is an essential component of the control that firms have in place. So they see it as quite a key part of fighting financial crime. They've actually warned Google recently that they will take legal action if they continue to accept advertisements for online financial scams. That's an increasing issue, including on social media. Then we have promotion restrictions on social media. So they've been engaging with social media firms. We've mentioned Google. The same applies to firms like Facebook and Instagram. Looking to ensure compliance with the restriction in Section 21, so the financial promotion restriction, when providing value-adding services. Again, an area that the FCA has been looking at quite a lot recently. Going through Parliament, there is the draft online safety bill, which will provide a wider regulatory framework for tackling online scams that are generated by individual users. And then finally, there are around 50 investigations open by the FCA involving unauthorized activity relating to a total of 183 suspects currently, and some of those are close to charging decisions. So that's what the FCA is looking at generally in relation to financial scams. But in relation to pensions specifically, their concerns, one of their key concerns has been around unregulated introducers and the advice that they give. So turning now to the next slide, which is around the options, as Kerry used to be known, the recent case, which has just gone through to the Court of Appeal. They've had a recent Court of Appeal decision that's partially overturned the High Court decision. It's important to emphasise the parcel aspect, because the unsuccessful aspect of the claim was the High Court decision in relation to the obligations in Cobb's Rule 211, and that's the best interest rule, the obligation to act in the client's best interest. So the High Court decision still stands, and the Court of Appeal hasn't yet provided further clarity on the extent to which the client's best interests do actually require SIP providers to assess the suitability of a proposed investment. So that's something that hasn't really been developed any further. But the interesting aspect for us now is the successful aspect, whereby Mr. Adams was permitted to unwind his investment and obtain damages under Section 27 of FSMA. So, and by the way, the picture of the storage poles on the last slide is because that's what the investment actually concerns. And it's a rare chance to use this kind of picture. So on to the next slide then, thank you. So Section 27, which was the key aspect that the Court of Appeal focused on. So Section 27 of FSMA applies where an authorized person, in this case a SIP provider, agrees to carry on, in the course of carrying on a regulated activity, makes an agreement. But the agreement was made in consequence of a third party breaching the general prohibition. And in such a case, the agreement is not enforceable against the SIP provider. So options in this case, Adams, rather, the appellant, argued that this had been breached, was unsuccessful in the court, in the High Court, but successful in the Court of Appeal. So in the High Court, in judging whether the introducer had contravened the general prohibition, they noted the need for a causal link between the act of arranging and the transaction itself. So merely effecting an introduction is not enough. They needed further acts to establish that there was this connection. The Court of Appeal disagreed with this and found that Section 27 did apply, and that's because in addition to recommending this investment in the storage pods, the introducer was also encouraging Mr. Adams to achieve that by transferring out of Friends Life policy and then buying this Kerry SIP, and both of those were regulated activities. So the transfers into the Kerry SIP were therefore brought about, in the opinion of the Court of Appeal, by arrangement undertaken by the broker. So they took a wider view. So in consequence of this, the CLP's arranging deals was arranging. This was in consequence of the introducer arranging deals in investment. Now, turning to the next slide, then. So, did the provider have actual knowledge of that the third party was contravening Section 19, so the general prohibition? Now, Kerry didn't actually have any knowledge about this, that the introducer was contravening the general prohibition, but the court still refused to exercise the discretion, so it had a discretion under Section 28 to enforce the agreement regardless. They declined to exercise this for a number of reasons, and these include a key feature of FSMA, as they saw it, is consumer protection. So this includes protecting customers from their own folly, in the words of the court. Not a novel concept in consumer protection legislation. The point of Section 27 is to put regulatory risk on the provider, so this is a conscious legislative aim, as the court saw it, where they choose to accept introductions from unregulated entities. So the risk is not to be borne completely by the consumer. The court also noted that Kerry had terminated the relationship with CLP after alarm bells had started ringing, including an FCA warning notice, but it still continued to allow pipeline cases such as that of Mr. Adams to proceed. So the court thought they really were on notice to take some action in relation to the introducer. And finally, in reaching the decision, the court also took into account that Kerry had taken on quite a large number of clients. There was quite a high level of investment, and in all the circumstances, Kerry really should have been concerned about the this introducer advising on investments. So putting all those things together, the Court of Appeal, really this does suggest that in view of this, firms will find it quite hard to escape liability under Section 27 if they accept any introductions from an unregulated introducer. They will have to carry out an analysis of the processes carried out by the introducer in order to be sure that they do not fall within the scope of Section 27. So quite difficult to see how going forward firms will be able to get comfort where they are accepting such introductions. And the final point there is the consumer protection responsibility. That this is quite there's been quite a movement again of the pendulum in terms of moving towards consumer protection and away from a fairly well-established principle of business that customers do take responsibility for their own actions. Okay, so on to the next slide, please. So the High Court claim failed because the judge found that the contract between Kerry and Adams was execution only. That was quite an important point for them there, and that the regulatory regime was not intended to take precedence over contractual terms. So they really put a lot of store in the fact that there was this clear agreement in place. However, in the Court of Appeal, Mr. Adams did try to develop the case further by including duties under COB 211R. And as I mentioned at the beginning, this was the aspect that was unsuccessful. And the Court of Appeal did dismiss this. They saw it as a radically different case. In particular, the duties that he tried to include were a product due diligence duty, a non-standard investments duty, or a financial crime duty. So these are all arguments that really the firm should have done a lot of due diligence in assessing the risk. But the Court of Appeal did disagree with those, so the law is still as it was in the High Court, and we don't have any further guidance on this particular, on the client's best interest rule. So that's my final section, so I'll hand over back to Suzanne.
Suzanne, you're on mute, I think.
Thank you, Sue. At least one of us had to do it. I was just saying, flowing from the options case, I hope it isn't only dispute lawyers that wait with bated breath for court judgments, but they don't always give the answers that we were hoping for or expecting. So I'll just comment briefly on what I think the options judgment means for SIP operators in terms of best practice. So for their, and Ralph has touched on this, but for their relationship with unregulated introducers, I think providers need to have in mind that the court's view was that the point of Section 27 is to put the regulatory risk on the provider when they choose to accept introductions from unregulated entities. So even though the case was decided on specific facts, including, as Ralph said, that they continue to process pipeline cases, there is a real risk for regulated providers that the buck will stop with them in this sort of scenario. So a clear lesson from this must be for firms to assess their relationships with third parties. So that includes at the outset checking that they're authorised, but if not, consider really carefully whether you're prepared to accept business from them and keep good records of these checks and the decisions made so that you can demonstrate your thought process if it's challenged later. And also, as Ralph touched on, assessing the processes carried out by the unregulated entity to ensure that the introductions fall outside Section 27, so they're not doing activities that should be authorised. I think there must be a question as to whether this checking and resulting business is really worth taking that risk. In terms of the COBS claim and the provider's contractual arrangements with customers, as Ralph said, the Court of Appeal decision hasn't overturned that, and contractual terms can determine the roles and responsibilities, for example, if the operator is acting on an execution-only basis. But best practice approach here is to continue to make sure that contractual arrangements are very clear, especially in documents reviewed or signed by the customers, and continue in line with all FCA guidance to ensure full, detailed and ongoing due diligence is taken, especially in relation to non-standard assets. Make sure all due diligence and decisions are documented and that good and complete records are made and retained. The FCA is very active in this area, and it issues, for example, Dear CEO letters to SIP providers. The one on the slide is in relation to assessing possible exposure risk. This leads on to other exposure, which is most obviously here in relation to FOS complaints as well as court claims. The Financial Ombudsman Service is provided for under FISMA, which specifically provides that it will resolve complaints in a way that it considers fair and reasonable in all the circumstances. This gives the Ombudsman considerable scope to decide against the regulated firm, even if they themselves consider themselves to be acting on the right side of court decisions, for example, Adams and Options. And it's worth noting, I think, that in its report, the FOS's report on 2020 to 21 cases for pensions and investment claims, the most complained about product was a SIP, and the highest uphold rate of those claims was in relation to SIPs at 56%. So the FOS encourages SIP operators to review its published decisions on similar matters when responding to complaints that they receive before they reach FOS, obviously to try and get a resolution for the customers more quickly, and that links back to what the FCA requires in terms of assessing exposure. So moving on to guidance for IFAs, I think it's worth noting that tackling scams is a strategic priority for the FCA into 2021. But I must say that the full scope of FCA's work on IFA guidance on pension transfers is unfortunately beyond the time that we have available today. They've been doing work on pension transfer advice for many years, not only in relation to scams, but just to improve member outcomes generally. There's almost been a constant stream of work by the FCA on pension transfers, including thematic reviews, consultation papers, policy statements, and finalised guidance. I will just highlight finalised guidance 21.3 that came out this year. It's the most recent finalised non-handbook guidance on advising on pension transfers, and it aims to support the development of good practice and processes within firms, and they're expected to use it to identify weaknesses in those processes and in order to put in place an appropriate framework for managing and delivering suitable advice, especially on DB to DC transfers. Other action includes its banning contingent charging in late 2020. And also this year, although it issued guidance on calculating redress for pension transfers in 2017, this has had some specific updates this year, and it's certainly something that advisors on pension transfers should be up to date with. It's also worth noting that guidance for IFAs on pension transfers is stated to be of interest and relevant to other players in the pension transfer process. So, for example, trustee schemes. So there's probably a bit of it around best practice and guidance for those regulated entities. But I need to hand over to Sue now, who will talk about upcoming changes to the members' rights, statutory right to a transfer.
Thank you, Suzanne. I think it is important to say that the great majority of transfers are actually legitimate. They are going to properly run schemes. So I just wanted to make that a point. But having said that, it's certainly true that over the last few years, and in particular since the pension freedoms came in, we are seeing trustee boards confronted more and more often with potential transfers out which their administrators have identified as being suspicious. So, for example, some of the red flags that we've seen are the member not being able to explain what their relationship is with the employer in the receiving scheme, or indeed the member not even having appeared to have spoken with the advisor who signed off on the advice required for them to take the transfer. And the current law is such that this has placed trustees in a really tricky position. because notwithstanding that they may have been presented with all of these kind of red flags and are extremely concerned that a transfer out may be a scam, as the law stands, if a member has a statutory right to transfer out of the scheme, then the trustees currently are unable to stop them from doing so, albeit that they obviously try and persuade the member not to do so. Ultimately, the member can go, and that was confirmed in the High Court judgment of Hughes on Royal London, and sort of widely acknowledged that this left trustees in a really tricky position. And this is now something which the government has recognised as well. The message has reached them. And it too has said it recognises that most transfers out will be legitimate, and obviously it's very supportive of member choice, particularly with the pension flexibilities. But it has also recognised that the current legislation gives trustees little scope to take action where they do have very strong concerns that a member might be about to be scammed. So what's the government proposing? Well, draft regulations to be issued under the Pension Schemes Act have been issued for consultation, and that consultation closed earlier this month. In terms of the strategic objectives behind the proposed changes, well, firstly, if it's thought to be a very low-risk scheme, then the government doesn't want to impose unnecessary barriers or prevent transfers to such schemes taking place. So that is very clear. However, they do want to give trustees a greater ability to intervene and be able to stop transfers where there are those very real red flag scenarios. And finally, we also have an amber flag scenario situation where there are some risks, but not enough that amount to red flags. And in that situation, it wants members to have to take specific guidance from the Money and Pension Service before they're allowed to proceed. But ultimately, that will be their choice. We could turn to the next slide. How does this translate into the proposed regulations? Well, trustees can take a different approach, as I said, depending on the risk of the scam and the nature of the scheme, the receiving scheme in question. So in terms of minimal or low risk, where no further due diligence or intervention will be necessary, that will be to a public sector scheme, an authorised master trust, and also a suitably authorised personal pension arrangement. If the transferring scheme isn't transferring to one of those schemes, but is, for example, transferring to a UK occupational pension scheme, the new requirement there is that the member must be able to show that there is an employment link with that scheme. And the onus is on the member to produce that evidence, so for example, evidence of employment earnings. CUROPS qualifying recognised overseas pension scheme, again there will be a new requirement for the member to show that employment link, or if there isn't an employment link, the member will actually have to show evidence that they've been resident in the same jurisdiction as the receiving scheme for at least 6 months. So what if you have a transfer which doesn't fall into any of those categories? Well, this is where trustees will be subject to the flag regime. And these flags are actually specifically written into the regulations. So the regulations will require trustees to consider all of the circumstances of the transfer out and the people involved and identify whether or not there are any red or amber flags. Now, I should say that it is actually open to trustees to continue to rely on their existing due diligence process, and all administrators have got these up and running now. They're not obliged to go further and ask extra questions. However, they do have the power to do so, and in practice, I would imagine that trustees and administrators will do so, and indeed the DWP has come up with a standard list of questions to assist them with that. If amber flags are present, as I said, the member must take Money and Pension Service guidance. And it's important to note that that is the case, notwithstanding that they may have taken regulated financial advice as part of the transfer process anyway. Indeed, these regulations will apply to transfers without exception, so notwithstanding that advice may have been taken. And they'll also apply to transfers from personal pension schemes as well. Some examples of amber flags. Well, a high risk or unregulated investments, or perhaps it involves some overseas elements, or there may have been a massive volume of transfers to a single scheme that has given rise to suspicions. Ultimately, though, in an amber flag case, the member can still decide to transfer out. In the red flag case, however, trustees can ultimately put a stop on the transfer. And I should say that in an amber flag scenario, if a member fails to provide trustees with information which they've requested, that in turn will turn it into a red flag case. So examples of red flags would be if a member has been contacted on an unsolicited basis, or if a member has been offered an incentive to transfer out, such as cash or the opportunity to access their pension benefits before minimum pension age. In that scenario, trustees will now have the power to stop the transfer. And so although I think actually trustees will probably welcome this extra power to take action where they're very concerned for a member's interests, I think it is going to place trustees in potentially quite a tricky situation. There's a lot of discretion here. And indeed, that is part of the purpose of the regulations. The Pensions Minister has said that he wants trustees to be in the driving seat. I think trustees are going to really want to do their homework before they stop a transfer, because I think they will be worried about the potential risk of a complaint from a member if that member is stopped from exercising their freedom of choice. Just briefly, I want to touch on the industry reaction to the proposed consultation. I think broadly welcomed. There is a concern that this could slow down legitimate transfer requests, that trustees might go over the top with the due diligence, and so there will be a fine balance there. And indeed, the government has recognised that it could give rise to some delays in the transfer process. The intention is to introduce the regulations this autumn, and so trustees and administrators will need to keep their eye out on those finalised regulations and update their processes accordingly. Now I'll pass to Amy for some real-life case studies.
Thank you, Sue. Hi, everyone. I'm going to take you through a couple of examples of tricky transfer requests we've seen in recent months, which are based on real scenarios. Case study 1 concerns Mrs. T, who was a member of a final salary occupational pension scheme. She held a statutory right to transfer. She was resident in the US and she asked to transfer her benefits to a US SIP. The transfer had been recommended to her by her US financial advisors, and as the transfer was for more than £30,000, she had to seek advice from an authorised FCA regulated advisor. Her US advisors introduced her to a UK-based IFA, but the UK IFA advised against the transfer on the basis that it wasn't in her best interest at the time. The IFA gave various reasons for this, for example, the fact that Mrs. T would be unable to access her pension benefits for the next 5 years if she transferred. Mrs. T voluntarily provided the trustees with a copy of the UK IFA's advice, and it's worth noting that although trustees must check that the member has received appropriate independent advice before they carry out a transfer, the regulator's guidance on DB to DC transfers is very clear that the trustees aren't expected to ask for the advice, nor are they expected to check it or to check what members are doing about it. And asking for a copy might put the trustee in a more difficult position than if they hadn't had sight of the advice. So it's not something that should be requested as a matter of course in a transfer situation. Notwithstanding the advice from Mrs. T's UK IFA, she asked to proceed with the transfer, and so she was deemed an insistent transferee. The administrator provided her with their standard warnings on scams and issued Mrs. T with a questionnaire to gather further information. Ultimately, they were happy that the necessary checks and due diligence had been met, and so they referred the case to the trustees. But the trustees in turn had some concerns, including firstly the fact that the receiving scheme was an international SIP. The industry recognises that international SIPs pose a greater risk to members, but they are acknowledged as a suitable vehicle in some cases for overseas residents. Secondly, an issue of concern was the disparity in advice provided by the UK and the US financial advisors. We identified a number of options to the trustee to give them additional comfort prior to the transfer being made. Firstly, they could reinforce the standard discharge wording that Mrs. T was asked to sign, for example, stating any concerns that had been identified and repeating the pension scam warning. Second, they could repeat the suggestion that Mrs. T contact Money Helper, formerly TPAS, to talk through the proposed transfer and any warning signs. And third, they could consider revising the pension scam warnings issued to potential transferees, perhaps, for example, to feature more prominently to the reader in the paperwork that they're provided with. Ultimately, the trustees chose the first of those options to amend the standard discharge wording, and Mrs T signed the revised wording, and the trustees were satisfied that the transfer could proceed. Moving on then to the second case study, which concerns Mr S. Mr S, again, was a member of a final salary occupational pension scheme, and he held a statutory right to transfer, and he asked via email, following a direct approach from an unauthorised advisor on LinkedIn, that the transfer be made to a QROPS, a qualified recognised overseas pension scheme, in Malta. The trustee obtained the necessary evidence to show that the receiving scheme was in fact a QROPS, so that wasn't an issue here. As with Mrs T, Mr S was required to take independent financial advice, and he produced a form signed by a Mr A, who was an IFA. However, in an email to the administrator, Mr S confirmed that he had received advice from a Mrs B. And given the disparity, the administrator asked Mrs B to sign a form to confirm that it was she who gave the advice to Mr S. And separately, they asked Mr S to complete an additional declaration form. That does highlight the importance of checking forms received against the information provided in communications with members, because disparities can and do occur. Mr S was then unresponsive to follow-up queries, and the administrator didn't receive the additional form back from Mrs B either. The lack of communication continued, save for a short email from Mr S confirming that he still wanted to go ahead, and the guaranteed payment date was fast approaching. So the administrator approached the regulator for an extension of time. The regulator said it didn't have time ahead of the payment deadline to issue a formal extension, but said it wouldn't regard the fact that a conclusion hadn't been reached before the guaranteed payment date as a breach of the law, because the trustees were clearly intending to make the transfer subject to receiving satisfactory due diligence. The regulator's assumption seemed to be that if the required due diligence was completed, then the payment would be made. And that's interesting on one analysis, because despite everything we've discussed today about a rise in scams, the message from the regulator in this scenario was that the due diligence was essentially a box-ticking exercise, and the transfer was expected to go ahead. The trustees proceeded on the basis of the extended deadline, but Mr S remained unresponsive, and that deadline came and went. The trustees were then concerned that that might mean that the transfer process has to be restarted entirely if Mr S wanted to proceed. And there were a few relevant factors that we identified here in determining what the trustees should do. Firstly, the regulator's guidance, which affords trustees the discretion to make a transfer where, after a failed due diligence check, they receive subsequent confirmation that appropriate advice has been received. Secondly, the regulator's response to the trustees' application for an extension of time, on the understanding that the trustees' intention wasn't to refuse payment, but rather to allow sufficient time to undertake appropriate due diligence. And third, communication with the member to date. The administrator had contacted the member during the extended period to ask if he still wished to proceed, and he responded briefly to confirm that he did. So to halt matters now and restart the process would probably be at odds with the member's expectations. Taking all of those factors into account, the trustees, on advice, decided to allow a further reasonable period for the checks to be completed. In this instance, 14 days was deemed reasonable, and to keep the member fully informed. Mr S failed, however, to return the completed forms within 14 days, and Mrs B also failed to return her signed appropriate advice form. And the trustees therefore took the view that they couldn't make the transfer at that time. It's worth noting that one of the red flags for trustees is a member being pressured to make a transfer quickly, and we saw possible glimpses of that at the start of this case, illustrated by the fact that Mr S made contact very quickly after responding to a direct approach on LinkedIn, but thereafter had very little personal drive to effect the transfer and to address the necessary due diligence. And of course, there could be various reasons for this, for example, illness, but a lack of responsiveness following a very keen initial request to transfer could be a risk factor to bear in mind. I hope that gives you a flavour of some of the tricky scenarios we're seeing. I'll now hand back to Suzanne to talk through member remedies.
Thank you, Amy. So our last topic today is what remedies, or rather what routes, are available to customers or members to seek compensation if they are a victim of a scam. First, I think it must be remembered that customers and scheme members who are victims of a scam should still go through the correct channels to complain first. before, for example, launching a court or an ombudsman claim. So, for example, for claims against trustees, if they think, for example, that the trustees failed to do the due diligence that they should have done, they should go through the IDRP process. And as I mentioned earlier, if they're claiming against an IFA or a SIP, those firms should have in place robust claim processes and also know how to calculate any loss due. So in theory, this should mean that customers who are entitled to it can receive compensation more quickly. But that's obviously not always the case, and other routes to seek compensation are obviously available. The Pensions Ombudsman, they hear complaints against occupational pension schemes, for example, against trustees or administrators, but it also has jurisdiction in relation to personal pensions, so SIPs, for example. The Financial Ombudsman Service, FOS, is available for complaints against FCA regulated entities. So this includes IFAs, for example, but also SIPs like the Pensions Ombudsman. And this does create a crossover, which has been criticised in the past, particularly because, as I said earlier, the FOS decides cases on what is fair and reasonable, whereas the Pensions Ombudsman decides cases on a judicial basis. And this can create sort of forum shopping issues for certain claims and some inconsistency in outcomes. There have been discussions in the past about resolving that issue or even combining the services, but I'm not aware that that is a current live debate, other than that they do have a memorandum of understanding between them in terms of approaches to those claims. Both Ombudsman services have commented on the prevalence of scams and also recently an increase in complaints stemming from transfers and loss and concerns arising from the COVID pandemic. I mentioned the Fraud Compensation Fund briefly earlier. This is a fund operated by the PPF, which I think it's fair to say was not designed with pension liberation schemes in mind. But the PPF has recently, I think last November actually, obtained a court decision to clarify how it should operate the fund. So it can compensate members of schemes used as liberation scams. But it's worth we should note that it's not an immediate route to compensation, in the sense that the schemes still have to go through a number of steps before calling on the fund. They include that to prove that an offence involving dishonesty has taken place, analysing member and financial information to see what compensation would be payable, and also the FCF is a last resort fund, so the independent trustees appointed by the regulator once those schemes are identified as liberation scams, those trustees will still have to actively pursue the recovery of scheme assets before claiming on the fund. Action Fraud is on the slide. It isn't a body which investigates or resolves complaints or provides remedies for members, but it is a national reporting centre for all fraud and cybercrime, and it should be contacted to report any scam activity. Its effectiveness has been criticised in the past, but it needs data on scams to share with all other organisations to improve warnings that can be given, efforts at prevention, and also to provide evidence in investigations. So it should certainly be on everyone's radar if dealing with a scam situation. The Financial Services Compensation Scheme is, of course, the statutory compensation body available when a regulated firm fails and itself would be unable to pay any compensation. I think it's important to note that in addition to the processing of claims and payment of compensation, FSCS focuses on other areas of activity under its 4 pillars of prepare, protect, promote, for example, its services, and probably most importantly in relation to scams is prevent, where it works closely with other agencies to share information and seeks to spot trends and prevent firm failures in the first place and take action on scams. As I mentioned earlier, a clear example of this is the analysis work that FSCS does in relation to phoenixing, where they share information to prevent that activity. Finally, there is the courts. Obviously, we've seen with Mr. Adams, the courts can provide remedies to customers who've lost their pension savings. Although I think it must be remembered that he didn't win at the High Court, and there was never any guarantee that he would be successful on appeal. And I would say the court must be considered as a last resort after the complaints processes and the Ombudsman services, for example, or if a member is entitled to FSCS compensation. It's important that members and customers are aware of those options. So even though there are various routes to compensation, with all the activity we've been speaking about today, I think we'd all agree that the focus undoubtedly must be on prevention rather than recovery after the scam has caused the damage. So that's the end of our presentation. We do have just over 10 minutes for questions, so I will just go to the questions box. Great. There are quite a few. So Sue, if we pick up with you in relation to transfers, what do you think the new regulations, if they come through in the current draft form, will mean for trustees in practice?
Well, I think firstly they'll have to work with their administrators to make sure that processes are updated and also that member communications are updated. So, for example, members will need to be told about the conditions that will have to be met when they first request a CETB. As I mentioned, a lot of discretion and power really being placed in the hands of trustees. So more important than ever that they stay up to date with developments around pension scams. So coming along to webinars like this, and also you mentioned TKU's, pension regulators TKU module on scams too. And then I think more widely, as you said, prevention is the key here. So trustees will be thinking about how they can engage with their membership in the run up to retirement and perhaps provide that education piece around member options. And indeed, we are seeing some trustee boards even starting to think about whether they might, provide recommended financial advice, for example. So a number of things.
Great, thank you. We have another one on the transfers, actually. So, Amy, it's directed to you. What difference do you think the new regulations would have had on the example transfers you discussed?
Sure. So in Mrs. T's case, the trustee would need to work through the conditions 1 to 4 that are set out in the regulations to decide whether they could proceed. In her case, the receiving scheme didn't fall within the types of schemes that are covered by conditions 1 to 3. So the trustees would then be looking at the 4th condition and the existence of red or amber flags. Arguably here there was at least an amber flag because an overseas advisor had advised Mrs. T in relation to her investments, which is one of the situations set out in the regulations. Once that amber flag is identified, the member would then need to provide evidence to the trustees that they have taken advice or taken guidance from Money and Pension Service. So I think you get to a similar point in terms of Mrs. T, in terms of identifying the warning signs to overcome, but the draft regulations set out a more formulaic way of addressing them. I guess you could envisage a situation where a member who considers themselves sophisticated enough not to have to take advice from MAPS causes a bit of a fuss, but if they don't take the advice or don't demonstrate that they've taken the advice, then the trustees can prevent the transfer from going ahead. In Mr. S's case, the draft regulations might have helped in that scenario because they provide a very specific route to asking further questions to determine whether a red or amber flag is present. Here, the receiving scheme was a cure-ops, so the 2nd or 3rd conditions are relevant, provided residency or an employment link is established. But ultimately, if the member fails to provide the information that the trustees ask for to determine whether or not the 2nd or 3rd conditions are met, or indeed whether there are any red or amber flags, then that in itself would entitle the trustee to prevent the transfer from going ahead. Hopefully that answers the question.
Yeah, no, I think it does. I hope it does. It's certainly the case that we've seen on one of the suspicious transfers that we dealt with together, that when the member was asked again to go and get advice from the Money and Pension Service, their view very much was that service sort of available for free wouldn't add anything to the IFA advice that they'd already got. And I think the impression certainly that the administrator had and their team dealing directly, communicating with the member, was very much that he regarded himself as a sort of sophisticated investor, having taken relative what he thought was quite expensive IFA advice, and that the Money and Pension Service wouldn't add anything to that. So I think it is going to be really important that the advice that is provided and has to be taken through the regulations is actually communicated and sort of advertised in the sense of a specialist advice and the risk of scams, rather than the members potentially at risk of considering it a sort of free advice service that won't really be of particular value. So I think that's something that's going to be really important for members to understand when going through the new regulations.
Yeah.
Just looking at other questions. So Ralph, there's one for you on the FCA action on scams. Do you think that this will result in a widening of the FCA's powers?
That's a real possibility going forward. And the FCA has warned or complained effectively that its powers don't go quite as far as it would like to. In particular, it's important to remember, while the FCA does keep saying it will take a proactive approach to investment scams, they issue a lot of statements. They've got this warning list, Scam Smart. You go online and look which firms are on that. They've obviously made a lot of noise about Google and social media platforms, but they are limited by the fact they don't have, under the existing framework, and despite all the investigations that are going, they don't actually have their own powers to prosecute fraud. And really the noise is mostly coming from one direction, as always. It's the consumer organizations saying we need to go further, we need to prevent any scams from arising, we need to make sure firms are held accountable for any advice that leads to unfavorable outcomes. So yeah, I mean, we saw in the Court of Appeal case also, the FCA was really asking the Court of Appeal to give more clarity on the application of COBS. I think they really are pushing for on the legislative side also for greater powers. They want to go further. There's a lot of pressure on them to go further. So yeah, the direction of travel is in that, is all for more powers, I think.
Yeah, I think going back to Mr. Adams' COBS claim, obviously, as you said, it wasn't heard by the Court of Appeal because they regarded it as radically different in the way that he'd set out the specific duties that he wanted to argue for. And as I said, in terms of best practice, it's very important that SIP operators don't wholly rely just on their contractual terms and still very much follow FCA guidance on their duties and due diligence, for example. But I think there will be, I expect there will be another case where somebody actually argues those specific duties against the SIP operator in the future, in the sense that it wasn't dealt with by Mr. Adams, but they are out there and may well be heard by a court at some point in the future. Of course, that's something we'll all look out for. There is another question, which is, if the trustees refuse to allow a transfer and it's subsequently decided it can proceed, can the trustees be held personally liable for any investment loss? Would liability insurance cover this? I think the main test, under the new regulations, once the trustees consider the information that they get on further questioning that they might make to the member around amber and red flags, the ultimate sort of test in the regulations is whether the trustees have a reasonable belief in the existence of a flag. And if a red flag does exist, then under the regulations they are allowed not to let it go ahead. So I think there probably will be some case law to discuss what, in particular factual scenarios, what a reasonable belief is. But that is, as Sue said, that does leave a lot of discretion with the trustees. So as long as the trustees go through a very robust process of recording the decisions they've made and the evidence that they've taken into account, then as long as they reach a reasonable decision, in the same way as trustees should make all of their decisions, then I think it will be a very have to be quite a high bar for a member to prove in a claim that the trustees didn't have reasonable belief in the existence of a flag. So I think that it does give the trustees discretion. So I'm hoping that the drive in the regulations is to give the trustees control, whether or not they want it, but actually give them the power to make reliable decisions. In terms of whether, if you do get a claim where the member is right that the trustees incorrectly prevented a transfer, the question of whether or not liability insurance cover should prevent this, then I think I'd be confident in saying that it should do, provided the trustees have gone through all of the right processes and obviously they haven't acted with any sort of gross negligence or willful misconduct. Then if they are found to have done some wrong under their operation of the pension trust, then the liability insurance should cover them. But I do think there will be a lot of complaints and cases playing out exactly what the reasonable belief test in the regulations means. We don't have any more questions that's come in. It's 10:59, so just to make sure that this finishes on time and everyone can get back to the rest of the day, I think I'll bring it to a close. I want to say thank you very much to the other speakers, to the WebEx host, and also Jacqueline Oliver behind the scenes at Burgess Salmon helps us arrange all these seminars, and say thank you very much to her too. So thanks very much for joining us this morning. If you do have any other questions that you'd like to put to any of us, please do email us. You'll receive an email shortly after we close today with a copy of the slides as well. So thank you very much, and goodbye.